You got a DUI. We've said it, now let's move on. My name is Matthew Konecky. I'm a DUI attorney in South Florida. Now, one of the biggest questions that I get when someone consults me about their DUI is, when can I get driving again? And that depends. There's a couple different ways that you can handle it, and we're going to talk about those. So let's first take a look at what happens when you get a DUI. When you're arrested for DUI, you have an automatic suspension of your license. One is either because you blew over the legal limit or you refused to blow. You could also get a suspension for refusing to give a urine sample or a blood sample, or you could get a suspension for having either alcohol or drugs in your system as a result of a positive urine or blood test. But let's take the most common example. When someone's arrested for DUI and it's alcohol related, there's a suspension that comes through the DMV for blowing over the legal limit or refusing to blow. Now, if this is your first offense, you have actually a couple different options. The first option, what many feel is the most safe option, is to enroll in DUI school within 10 days and have a waiver hearing. Now, what a waiver hearing is you waive your right to an administrative review hearing or a formal review to challenge the suspension of your license. So for $25 in enrollment of a DUI school, you can have a hearing set up and you get to plead your case on why you need a hardship. Most of the time, most people are given a hardship on their first offense. Now, that hardship license is what's called a business purposes only license. That license will allow you to go to work, go to school, go to the grocery store, go to church, something like that, for business purposes. So if you get that hardship, it allows you to get driving right away. But what's important is that you got to request that within that 10-day period from the time that your license is suspended for getting the DUI, usually at the time of your arrest. Now, there is another option to that, and that's called a formal review hearing. So also within that same 10 days, you can request a formal review hearing and have essentially what's called, it's like a mini trial to challenge the validity of your suspension. So you might ask yourself, why would I want to do that? Well, there might be a number of different reasons why you may want to do that. There may be something faulty in the police procedure that would allow you to challenge the suspension and get your license back. The other reason why you may want to do that is if you look at the paperwork itself, you could see that there might be some sort of deficiency. I had one case where someone's refusal affidavit wasn't properly filled out, and because of that, my client was able to get their license back right away. So when you request a formal review hearing, that hearing is set about 30 days out. The DMV, upon request, will give you a permit if your license is otherwise eligible. So getting back to the original question, why would you also want to do that? If you weren't otherwise eligible for a hardship right off the bat, for instance, this is your second DUI, or you had a suspended license at the period of time that you got your DUI, you could request a formal review. That way, if you were able to clear your license and you prevail at the formal review hearing, you could drive right away. So this is a process, most of the time, somebody who, without any kind of experience in practicing law may not understand what those subtle differences are, and that's one of the reasons why you want to consult with an attorney who has DUI experience, who could take a look at the paperwork from the DMV within that 10 days and evaluate, do you have a good case to take for a formal review, or should you just get your hardship? So that is something that I do for my clients, is do an evaluation at that time. But I want to talk to you a little bit further why you still may want to do a formal review hearing. Because not only when you get arrested, you have a suspension of your license, you also have a criminal case. Most of the time, DUIs are only in county court, and under Florida law, you're not entitled to depositions. However, if you are pursuing a formal review hearing, you may have the right to subpoena officers to come to this review. That means you get to ask the questions of an officer about the case while they're under oath. State attorney is usually not present for these types of hearings, so you have free range to request and talk to the officers about exactly what happened. Most of the time prior to this criminal case even gets to court for the first time. So it's really a unique tool that you can use to develop your DUI case. So that may be, again, another reason why you would want to do a formal review. Ultimately, if you prevail at the formal review, you get your license back. There's no suspension on your license. However, this brings me to the next point is, if you get convicted of a DUI, your license will also get suspended. So you may be thinking to yourself, well, what if I was already serving a suspension based on the DMV? Well, the truth is, if you get convicted of a DUI, you could serve a second suspension for the same crime. Doesn't make sense to me. It doesn't make sense to a lot of people, but at the same time, that's the law as it is right now, and there's probably nothing that's going to change that. So, terrible case scenario is that you prevail at the formal review, and then you lose at trial, or you get convicted of a DUI, then you have to serve the suspension. Or in a really bad situation is you're, serving a suspension for your initial DUI through the DMV, and you get your license back because you served your time 6 months for breath over the legal limit, or 1 year for a refusal. So let's say your case takes 1.5 years, and then you get convicted, you could serve a second suspension for 6 months. So it's very important that you have competent counsel who understands these types of rules and how to deal with that situation, because at the end of the day, if your DUI gets dismissed, you could still be serving a suspension from the initial DMV suspension. There's a couple tricks around it. If you were able to get a not guilty at trial, upon motion, the DMV will sometimes reevaluate the initial suspension. So there is a importance of having a DUI attorney on your side who understands how to deal with getting your license back, or getting you a provisional license or a hardship license, and help you navigate those waters. This is what we do. So if you want to know more about DUI and law in Florida and how it pertains to you, I've written a book, and I have a special report. So my book is called My Loved One's Been Arrested, What's Next? And it's available for download at my website. And if you contact me directly, I will send you a hard copy of this book if you want the hard copy, or you can just download a PDF copy. Also, if you have a specific question about DUI, it will probably be answered in what you must know about your DUI case before you do anything. And a lot of the stuff I talked to you today about is going to be in here. However, there's some other things that you must know about your DUI before proceeding forward. That is also available for download from my website. So go to 561law.com. You can look at, I have a lot of different resources on my website. These are just two that pertain to DUIs. So you can review them, download them, and help you with your case. You can give me a call and I'll send you a copy if you'd like. We're here to help. So thank you for listening.